Get what kind of go to work? You want fruit punch? Miss Bridgewater.
Yes, how are you?
Hi, I'm well. I just sent you an email in regards to Mr.
Is that the guy from
Whitehead.
Yes.
Yes.
Okay.
So that should resolve his case. And I think the jail, the last time this came up, asked us to modify the bond and
Okay,
just,
I have two bond orders right
oh,
here.
great, 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 great.
So let me see which one is the correct one. I have one as a surety bond and one as a SOB through the jail. So which one am I using?
It's going to be the SOB through the jail.
Okay, great. I'll
Okay,
get the
that's
judge
it.
to sign it today then. I'll get rid of this one here.
Thank you.
You're welcome.
All right, good afternoon, everyone. We're going to go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams, and at this calendar today, we will address matters for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say can and will be used against you. You have a right to counsel today. As you can see, I am conducting this hearing over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I am referring to. All right. Can we take Ms. McLeod's cases first?
Your Honor, before we do that, can I give you your reset date for the
Yes.
SAT calendar?
Yes, ma'am. I would appreciate that. Thank you, Ms. Bridgewater.
You're
What is my
welcome.
reset date?
It's going to be June the 24th.
Thank you. Those who receive a signature bond will be reset. Further notice, those who receive a surety or a cash bond will be going to our state all-purpose calendar on June the 24th, whereby aspects of the case, including the bond that I set today, contact provisions, and other matters may be addressed at that point.
Your Honor, we have position 16, Ms. Tomlin.
Thank you. Ms. Tomlin, your case is 25 CR 003252G. You are charged with simple battery in this case. Do you understand your rights today?
Yes.
All right, thank you so much. Mr. Howard? Are you present?
I can give the history, Your Honor.
Sure, go ahead, Ms. Falk.
Ms. Tomlin has one 2024 theft by receiving marijuana less than an ounce that was dismissed. No other open arrests other than this case.
Thank you, Ms. Falk. If you would proceed with your recommendation as well, I'd appreciate it.
Yes, Your Honor. This happened June 6, 2025. Officers spoke to Rochelle Jones, who stated she had been in a relationship with Markevius Tomlin for about 9 months. Mr. Tomlin struck her in the nose, causing her nose to bleed, and the Miss Quiana Tomlin and the mother of Markevius Tomlin and his sister, who's the defendant, physically assaulted her. The defendant did admit to pushing and hitting Miss Jones. Markevius Tomlin did claim that Miss Jones' mother called asking why Miss Jones' nose was bleeding. He claimed he didn't know. Based on the victim's injuries, the defendants were arrested. Miss Quinia Tomlin and Markevius Tomlin actually came before us yesterday. Miss Quinia Tomlin, whose criminal history is nearly identical to this defendant, received a $2,000 signature bond through pretrial services level 1-day anger awareness, no further contact with Rochella Jones, stay away from the residence of Miss Jones, no alcohol, drugs, or weapons. We would recommend the same as to this case, Your Honor. We would at this time like to sound for Miss Rochella Jones, and that's all for the state.
That's the direction I was leaning with this. Is Miss Jones present and wishes to make a very brief statement? Hearing none, Ms. McLeod, any objection?
No objection, Your Honor. Although my client did tell me that she believed Miss Jones was alleging that they actually lived in the same household, and she just wanted it to be placed on the record that they do not live in the same household, that she lives with her mother and her aunt at a completely different address.
Okay, so she shouldn't have problems with the stay away then.
Right, from Miss Marquita Jones's address. She says Miss Marquita Jones does not live with them.
Okay, so let me clarify. The stay away address is alleged to be her own home, or is Ms.
No, Your Honor,
Jones's
we
home?
just asked that she have no further stay away from the residence of Miss Jones. We were not alleging that that was the residence where the incident happened.
Okay, that's what I thought. All right. Defendant is going to receive a $2,000 SOB at level 1 through pretrial services. She's going to take the 1-day anger awareness course, have no further contact with Miss Jones, stay away from wherever Miss Jones resides, have no alcohol, drugs, weapons, and will be reset further notice. Best of luck to you, Ms. Tomlin. That concludes your case.
And Your Honor, did you give the 1-day anger awareness?
I did 1-day anger
Okay,
awareness.
thank you.
I thought I said it first, but if I
No,
didn't,
I
please add that.
may have been processing something else. Thank you, Your Honor.
Okay, 1-day anger, yes. All right. Who do we have next?
That concludes my business before the court today. May I be excused?
Bye, Ms. McLeod. Are we sure that we don't need you for anyone else? Everybody else is not conflicted out by the public defender's office?
That is my understanding, Your Honor.
Okay, hopefully we won't have to call you back. Thank you, Ms. McLeod, as always. Take care. Have a good afternoon.
You too.
All right, who we have next?
4, Brown, Robert Brown.
Robert Brown, yeah.
Okay, Mr. Brown, your case is 25 CR 003248C. You're charged with criminal trespass. You understand, right? Is that a yes? All right, Mr. Howard.
45 on probation for well, you said 2025 FTA 24 no low for trespass, another 24 trespass no low, 24 theft by taking conviction, 24 trespass no low, 23 trespass conviction, 23 trespass no low.
That's good. I got it. I got you. Thank you. All right, Mrs. Sirocco.
Good afternoon, Judge. Thank you. This incident took place June 7th, 2025 at 2907 Main Street in Atlanta. It's the CVS at the location. Law enforcement was dispatched to the location in reference to trespassing. Upon arrival, the officer spoke with the defendant, who matched the clothing description given. The officer checked through GCIC and discovered that he had an active criminal trespass warning from that location that was issued October 17th, 2024. A CVS employee explained that the defendant had entered the business and was asked to leave. He was previously issued that trespass warning after he was coming into the store, constantly stealing merchandise. He admitted he understood what a criminal trespass was when the warning was issued. He was placed under arrest. The state will consent to a signature bond through pretrial services. Stay away from the CVS at 907 Main Street, Atlanta, and no drugs, weapons, or alcohol while out on bond.
You're saying you want a signature bond in light of the other? Okay. All right. I'm not sure that I'm going to do that.
Is that FTA open, Judge? Well,
Sounded like it. Plus, he has all those criminal trespass convictions. But okay, that if that's the state's recommendation, I'm not sure I'm going to go with that. Ms.
Right.
Tucker, please proceed.
Um, yes, Your Honor. We're also requesting a signature bond on Mr. Brown's behalf. He's a 32-year-old Atlanta native. He is currently homeless. He's completed his education up to the 12th grade. He said he is more than willing to stay away from the incident location. And due to not having income, he wouldn't be able to afford a surety or a cash bond at the moment. So we are requesting a signature bond on his behalf.
Okay. All right. Defendant's going to receive a $5 cash bond. He's to stay away from that location and have no alcohol, no drugs, no weapons. That's a condition. Because he did get a cash bond, he is being reset to the all-purpose calendar. Is there anything additional?
Nothing from the state, Judge.
No,
All
Your
right.
Honor. Thank you.
All right. Best of luck to you, Mr. Brown. That concludes your case. Who do we have next?
That was $5.
Yes, ma'am. $5 cash.
Next, we have position 5 and 6, Davis.
All right, Mr. Davis, your case is 25 CR 003256Y. In that case, you're charged with simple battery and simple battery family violence. In case ending in 3257G, you're charged with battery family violence and simple battery family violence. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
7. You got an open battery terrorist threats out of Clayton County. 2024 FTA, 2023 battery DB, 2019 disorderly conduct conviction.
Okay, thank you. Mr. Sirocco.
Thank you, Judge. On the first case, it's position 5 with the 2 simple battery charges, one being family violence. This incident took place on April 16th, 2025 at 4001 Lakemont Drive in College Park. It's an apartment complex. Law enforcement responded to a domestic dispute call and upon arrival made contact with the victims in this case, Miss Rachel Bridgman and her father, Mr. Perry Bridgman, who explained that the defendant, Miss Bridgman's live-in boyfriend, had attacked them both. Prior to the physical altercation, the defendant was upstairs trying to put baby to sleep. He became frustrated because the baby was crying, wouldn't go to sleep. And when the victim came and took the baby from the defendant to try and make it happen, he became angry. The two started arguing, and Miss Bridgman ultimately gave the infant to her mother. And at that point, they got involved into a physical altercation with grabbing. The situation escalated when Miss Bridgman took a game she'd purchased and told the defendant she was going to call a rent-a-center to come pick up. Not really sure exactly what that all meant, but basically the defendant became upset over this, grabbed Miss Bridgman and pushed her in the chest. When Miss Bridgman's father, Mr. Perry Bridgman, tried to get in there, the defendant pushed him and Miss Bridgman both in the chest. The defendant left the scene before law enforcement arrived and a warrant was issued for his arrest. With the second case here, that incident took place less than 2 months later on June 9th, 2025 at the same location. Law enforcement responded to a domestic disturbance call and upon arrival was flagged down by the victim, the same victim as one of the previous, Miss Rachel Bridgman, who was the one who called the police. She explained that the defendant had struck her with an open hand, slapping her in the face. She explained that the defendant has been abusing her for quite some time and that she wanted to get away from him. The victim sustained a scratch to her right forearm area and other scratches to her forearm area, the other forearm area from the incident. And the defendant actually admitted to slapping Miss Bridgman in the face. He was arrested. As you heard from pretrial, there are a number of violent cases for which he's been arrested, and many of which are still open. That the battery and terroristic threats and acts in Clayton County, 2024. You have that other battery. There's another battery in Clayton County, 2023, that's still open. 2 other open battery cases in Clayton County. one being battery, the other being battery of school personnel from 2024 and 2019 respectively. And you have the open battery family violence, simple battery family violence, simple battery from 2024 that's open in Clayton County with the 2024 CR 02167 case number. We've spoken with the victim in this case. They are in a relationship, and she confirmed they live together at the incident location, sharing a child. She confirmed the events in both warrants, explained that these are not the only times the defendant's been violent towards her, but these are the only times she's called the police. She's explained that she's planning to file up for a TPO and that she is in fear of the defendant and does not wish to have contact. She explained that she wants the defendant to stay away from the residence and that he would need a law enforcement one-time escort to retrieve his belongings. She should be on the Zoom. We would ask the court sound for her when appropriate. Given that these are two family violence cases against the same victim. Oh, and we would ask to sound for Mr. Bridgman as well. Given that, we know also that these aren't isolated incidents, that this defendant has been arrested for battery, among his other arrests for violence, on 4 separate cases since 2019, including the open battery family violence case in Clayton. He poses a substantial risk of reoffense to this victim and a risk to the community. And with his recent FTA from 2024, I can't remember if pretrial mentioned that, but with that, he posed a risk of failing to appear for court as well. As such, the state is asking for a $10,000 total surety between the two cases. On the first case, which is position 5, a $5,000 total surety, $3,000 surety on the simple battery family violence, $2,000 surety on the simple battery. No further contact with Rachel Bridgman, no further contact with Perry Bridgman. Stay away from the incident location, that 4001 Lakemont Drive in College Park. No drugs, weapons, or alcohol while out on bond. And for the second case, position 6, $5,000 total surety, $3,000 on the battery family violence, $2,000 on the simple battery family violence. And for him to complete FFIP, have no further contact with Rachel Bridgman, stay away from the same incident location, and no drugs, weapons, or alcohol while out on bond.
All right, is Ms. Bridgman present? Wishes to make a very brief statement? If so, please turn on your camera, raise your right hand. You are not required to make a statement, however. Okay, is Mr. Bridgman, Mr. Perry Bridgman present and wishes to make a statement? You're not required to make a statement, but if you wish to do so, turn on the camera, raise your right hand. Okay, Ms. Bridgman, you wish to make a brief statement, unmute, and I'm going to give you some instructions, okay? Unmute.
Okay.
Do you swear or affirm the testimony of today be the truth to the best of your knowledge?
Yes.
All right. Now, what I'm most concerned with is not whether or not you disagree or agree or want to add to the facts that we just heard. That's not what's of critical importance today. What's most important is the concerns you have for your safety and whether you wish to have contact with the defendant. In light of those instructions, what would you like to tell me?
I just don't want him anywhere near me or my child or my family anymore.
Okay. Is there anything else you'd like me to know?
No, ma'am.
All right.
Could I ask her one brief question, Judge?
I don't, is it critically necessary? I think we've got the flavor of this case, Mr. Siraka.
I would say it is.
Go ahead, go ask her a question very quickly.
I just wanted to ask, are you the victim in the 2024 battery family violence case in Clayton County?
I don't believe so. I think you're referring to the incident that happened between him and his uncle.
Okay, thank you.
Mm-hmm.
All right, thank you. All right, Ms. Tucker, if this is your case, please proceed.
Yes, Your Honor. Mr. Davis is 28 years old. He's been in the Atlanta area for about 10 years now. He's resided at the address that's listed as the incident location for about a year now. He stated that his name is on the lease along with Ms. Bridgman. He has no objection to going no contact with the victim. He is currently not employed, although he does have a certificate in HVAC. He's trying to gain employment. He has an interview coming up on the 17th, so he does not have income at the moment. Although he does have a failure to appear on his history, we are requesting a signature bond, if not the lowest possible surety that the court would allow in this case, due to his financial situation, as well as them having a 4-month-old child. That's what we're requesting right now, Your Honor.
All right. For position 5, ending in 3256Y, defendant is going to receive a $2,500 surety bond, $1,500 on count 1, $1,000 on count 2. He's to stay away from that location, have no contact with either of the alleged victims in that case. For the case ending in 3257G, defendant is going to receive a $2,000 surety bond, $1,000 on each count. He is to have the same conditions, stay away from that location, no contact with Ms. Bridgman, no alcohol, drugs, no weapons. And he can have a one-time law enforcement escort should he need to collect any items. Is there anything additional from the state or from the defense?
No, Your Honor.
No, Judge.
All right, best of luck to you, sir. That concludes your cases at this time. His case will be readdressed at state of purpose on the 24th.
Next, we have position 7, Dunlap.
All right, good afternoon, Mr. Dunlap. Your case is 25 CR 003258Y. You're charged with simple battery, family violence. Do you understand your rights?
Yeah.
Mr. Howard?
10 total, 2022 trespass first offender, 2010 battery conviction, 08 burglary dead docket.
Okay, thank you. Mr. Sirocco?
Thank you, Judge. This incident took place May 29th, 2025 at 502 Princeton Drive in Palmetto. Law enforcement responded to a dispute call and upon arrival met first with the defendant, who exited the residence and stated that he was hit by his wife. The officer asked if he needed medical attention. He said no. Examined the defendant's head, didn't observe anything there. Officer then spoke with the victim, Miss Jamoke Dunlap, who is the spouse of the defendant. She explained that there was a series of verbal disputes that she and her husband had gotten into since the previous day, with one of them being about the defendant's work. And there was some bit about him later advising that his wife got him fired from a temp job, about which he was upset. At some point, this was over the course of that period to the next day, the Miss Dunlap actually came back and reported what actually happened to police, showing them video footage of this. And it showed that Miss Dunlap was sitting on a downstairs sofa holding their newborn child when the defendant began to attempt to pick up the child from out of her arms, forcefully pushing and tugging her in an effort to seize the child. Juvenile MD. This incident took place in the presence of their other juvenile child, HS. And as I said, there is the video that was from the Ring home camera footage showing the physical contact the defendant was making. And it showed exactly that, forcefully leaning over his wife, trying to take the baby from her when she told him no several times, holding their child. A warrant was issued for the defendant's arrest. I will supplement a little bit here. The defendant does have a battery conviction from 2010 that's out of Florida, and a few other arrests for one being battery and simple battery that's older in 2007. That was Noel Prost. And I believe, yeah, that about covers it. I've spoken with the victim in this case. She confirmed they are married, but they are going through a divorce currently. They do live together at the incident location and they share one child. She confirmed the events in the warrant and the police report, explaining that this is not the first time the defendant's been violent towards her, but it is the first time there's been an actual arrest for it. She explained that she is in fear of the defendant and wants no contact. She states she wants the defendant to stay away from the residence and that the defendant would need a one-time law enforcement escort to retrieve his belongings. She is okay with third-party transfer of their child. And I believe I saw Ms. Dunlap on the line. If the court could sound for her when appropriate. With this not being the first incident of him being violent towards her, his prior battery conviction and his other cases involving battery and false imprisonment, state's asking for a $4,000 surety bond here. 2-day anger awareness, no further contact with Jamoke Dunlap. Stay away from 502 Princeton Drive and Palmetto, and no drugs, weapons, or alcohol while on bond.
Okay. Ms. Dunlap, I see you on Zoom. If you wish to make a statement again, please raise your right hand and unmute. You're not required to make a statement if you don't wish to. No statement. Okay, understood. Thank you. I appreciate you coming to court. Ms. Tucker?
Yes, Your Honor. Mr. Dunlap is 39 years of age. He's been in the Atlanta area for about 30 years now. He's completed some college. He actually plans to leave for Stevenson Transport. It's a trucking school on this coming Thursday for a 4-week course. He returned to the incident location to retrieve some of his items, and he actually called the police to get a police escort to retrieve some of his property so that he could pack and leave for trucking school when he found out that he had this arrest warrant. So that's how he got picked up for this, because he contacted the police. He does not have any prior failure to appears, so I believe it's appropriate to request a signature bond on his behalf. We have no objections to no contact with the alleged victim in this case, as well as not returning to the incident location. As I said, he was trying to pick up his property as he was planning to leave anyway.
All right. Defendant's going to receive a $4,000 signature bond at level 1 through pretrial services. He's to still take that 1-day anger awareness course, have no contact with the alleged victim. Again, should he need to get any items from where the location he needs to return, one time with law enforcement to do so. Otherwise, he is to stay away. He's to have no alcohol, no drugs, no weapons, and he will be reset further notice in light of the signature bond. Is there anything additional?
No, Your Honor.
Another from the state judge.
All right, best of luck to you, Mr. Dunlap, and all parties concerned. Who do we have next?
Next is position number 8, Freeman.
All right, Mr. Freeman, your case is 25 CR 003266C. In this case, you're charged with theft by receiving. Do you understand, right?
Hold on, Your Honor.
Oh, I'm sorry. I didn't even realize the party had not made it there.
Rashawn Freeman. Mr. Freeman, have a seat here.
Mr. Freeman, you don't want to have your case heard today? Please come quickly.
That's the judge up there.
All right, do you understand your rights today? No. All right, Mr. Howard.
7. History mainly consists of driving. Last arrest was in, I think, the early 2000s for theft. That's it.
2000s? Okay.
Yeah, it's like early 2000s. And that was dismissed, if I'm not mistaken.
Okay, understood. All right, Mr. Sirocco, please proceed.
Thank you, Judge. And I do see the same, except I believe it was a conviction for willful obstruction, 06. So that at least wasn't dismissed. This incident took place yesterday at 5021 Old National Highway in Atlanta. Law enforcement responded to a strong-armed robbery call. Upon arrival, the officer began investigating this incident, which and looked into the security footage of this incident, which showed that the victim, in this case, Mr. Desmond Price, was being assaulted by an unknown male. He was rendered helpless on the ground as multiple subjects were observed on camera taking his property off of his person forcefully. And one unidentified subject had removed his shoes from his feet, a pair of Jordan 11s, and walked off toward the Mint Lounge, which is near the incident location, handing the shoes to then the defendant here, who was seen on camera watching the robbery occur and proceeding away with the shoes after he received them. He admitted later after the police made contact with him that he hid the shoes, and they were apparently in the wood line, and officers didn't see them there, then said they were in a different room at the hotel nearby. The defendant was wearing the exact same clothing he had on camera, and the shoes were valued at around $200.
So he took some shoes. He took some shoes. Okay, I think I've got it. Go ahead, Mrs. Rocco.
Okay. State's asking for a signature bond through pretrial services, an anti-theft course, no further contact with Desmond Price, Dazmond Price. Stay away from 5021 Old National Highway in Atlanta, and no drugs, weapons, or alcohol while out on bond. We would ask the court sound for Mr. Price if he's on the line.
Is Mr. Price present? Okay, Ms. Tucker, do you object to a signature bond through the jail and a stay away from that location?
No objections, Your Honor.
All right, defendant's going to receive a $5,000 SOB through the jail. He is to stay away from that location, have no contact with Mr. Price, have no alcohol, drugs, or weapons, and no further violations of Georgia law. He'll be reset for the notice. Is there anything additional?
No, Your Honor. Thank you.
No, Judge.
All right, who do we have next?
Next is position 10, Ms. Griggs.
All right, Ms. Briggs, your case is 25 CR 003263A. You're charged with battery, simple battery, and obstruction. You understand, right?
No.
Yeah, all right, Mr. Howard.
10th arrest. Last arrest was April 10th for obstruction out of Clayton County. 2020 simple assault DV, 18 battery, 2017 and 14 failure to appear, 2014 battery conviction.
Okay, thank you. Mr. Nixon?
Yes, Your Honor. Good afternoon.
Good afternoon.
This incident occurred on June 8th, 2025. The victim, Bobby Beasley, was punched with a closed fist by the defendant. The defendant received the victim received a visible bruise on the left eye, which was photographed. And upon attempting to arrest the individual, the defendant refused to comply with lawful commands regarding getting up from the ground. The defendant's history, again, that's a 2017 battery, criminal trespass. That was 10-day confinement, credit for time served upon a different victim, and then a 2018 battery with dissemination of information relating to terroristic threats via the computer, as well as cruelty to children, but a different victim, as well as the 4 FTAs I counted between 2014 and 2017. As such, due to the history of violence and this violence act against Bobby Beasley, the state is recommending a $2,000 surety bond for the battery, a $500 surety for the obstruction, and a $1,000 surety for the simple battery. No further contact with Bobby Beasley, and a stay away from the address, which is 4795 Main Street, and that's in Union City. Anger awareness, no alcohol, drugs, or weapons while out on bond, and the state will request that the court sign for the victim when appropriate.
Okay, is Mr. Beasley present, wishes to make a statement? Okay, hearing none, Ms. Tucker?
Ms. Griggs is a 28-year-old Atlanta native. She's completed up to an 11th grade education. She does have 2 minor children who she's the primary caregiver for. However, she is not currently employed, so she would not be able to afford a high surety bond today. So although she does have a prior failure to appear, we are going to request a signature bond on her behalf. If not, the lowest possible surety that the court is willing to allow today. We have no objections to staying away from the incident location, as well as no contact with the victim, as well as the rest of the state's recommendations at this time. Thank you.
All right, defendant's gonna receive $1,000 surety bond broken down 500, count 1, 250 on each remaining count. She said have no contact with the alleged victim, stay away from that location, have no alcohol, drugs, weapons, and she is going to all purpose on the 24th. All right, who do we have next? Best of luck to you, Ms. Griggs.
Would you repeat that again, Your Honor, please?
1,000 surety, 500, count 1, 250 on each remaining count for that total of 1,000.
Thank you.
Thank you. Can we take Attorney Walker's case next?
Next price?
No, walk.
Judge, how you doing this afternoon?
I'm wonderful. Hold on, I don't see that name on the calendar. Is it on the add-on? Who's your
It was
client?
on yesterday, and they called me and said he was on today.
And
It's
who's your client?
Your Honor, it's Demond Walker.
Demond Walker, charged with, I think, battery.
All right, Mr. Walker, your case is 25 CR 003213E. In this case, you're charged with simple battery against a pregnant female at the time of the offense, simple battery again, and 2 counts of each. So you have 4 counts total with the offense date of October the 23rd of 2024. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard, can I have that history, please?
Second adult arrest. Went to felony yesterday, I think, and got no bond for the FS charges. Got an open 24 PR 004704. Possession of sawed-off shotgun, marijuana, seatbelt violation, and tent violation.
Okay. All right, thank you, Ms. Falk.
Yes, Your Honor. This happened October 24th of 2024 at 2399 Wexford Drive in Atlanta. Officers spoke with Shamaya Zilman, who stated that she and the defendant, the father of her unborn child at the time, were in an argument. The defendant then grabbed her around the neck with both hands and began choking her, and then pushed her to the ground and held her down. The defendant then prepared to leave and he threw her phone to the ground, breaking it, and then cutting up pictures that belonged to Ms. Zilman. Ms. Zilman stated this was not the first time the defendant had tried to harm her throughout her pregnancy. As you've heard, this defendant has 6 cycles, 2 arrests for theft by receiving in 2021, an open aggravated assault case. That incident occurred May 27th, 2024, about 5 months before this incident. The defendant is alleged to have shot into a home where 5 people were inside. Possession of firearm during commission of a felony is also charged in that case. Then you heard the PI case where he has no bond. He also received a $3,600 split bond on a 24 PI 004704 case by Judge Borski on July 2nd of 2024. So he currently has 2 bonds outstanding, the no bond and then that $3,600 split bond for his other PI case. We are requesting a $10,000 surety bond, $2,500 per count, no further contact with Ms. Zilman, stay away from 2399 Wexford Drive in Atlanta, no alcohol, drugs, or weapons, and we are going to be asking for FVIP in this case. At this time, we'd like to sound Ms. Zilman, and that's all for the state.
All right, is Ms. Zilman present? Okay, hearing none. Mr. Walker, please proceed.
Judge, good afternoon. How you doing?
Good afternoon.
Judge, I apologize. I'm in the state of Texas. Daughter had a baby, so we had to come down Saturday. I did a hearing on his new charges. That incident occurred last year in April of 2024. It occurred before the incident that he's out on bond with. And when the state said that the fact that he shot into the house, we disputed the facts. The facts were that the alleged victim, who was charged with murder in DeKalb County and is out on bond from prison, he shot into the defendant's mother home and the 5 persons or his 5 siblings that was in that house. So the state, Mr. Webb, agreed he had it all backwards. But that's set aside and being said for these charges. And I was told he had these misdemeanor charges today. I received a text message from whoever this victim is or the mother, saying that the case is with with me, his baby mother, and saying that she didn't want to press charges. And I tell people, even though you decide you don't want to press charges and you say that you don't want to do A, B, C, and D, until you come to court and say that in front of the court, that is no avail. So, Ms. Shelley, I would concede to the bond, $2,500 a piece, $10,000 surety bond.
Okay. All right.
Forgive me, Judge, I apologize. You was talking real quick. I didn't get the actual, you said 25 CR. If I
Yes,
get that
I
case
apologize. I'll go slower. 25 CR 003213E. Defendant has 4 counts. 2 of them are simple battery against a pregnant person, and the other 2, one other one is simple battery. The other one is simple battery and family violence.
Okay.
All right, what we're gonna do is, I'm not gonna quite do that $10,000 bond, even though defendant is not necessarily objecting to it. We're gonna do 8,000, 2,000 on each count. For the total of 8, he's to have no contact with Ms. Zillimon, stay away from that location, have no alcohol, drugs, weapons, and he's gonna be reset to the state all-purpose calendar on the 26th. It seems like as he has no bond, that case will actually be reset there, and aspects of the case can be readdressed at that point. Okay?
Thank you, Judge.
Your
All
Honor,
right.
that date is the 24th.
I'm sorry, the 24th. I don't know where I got the
Is
26th.
it June 24th?
Yes,
sir.
2 weeks about.
Thank you.
All right, Mr. Walker, you can be excused. Have a good afternoon and best of luck to you, the other Mr. Walker.
Thank you, Your Honor.
All right, have a good day. Who do we have next?
Next is position 13, Ms. Moore.
All right, Ms. Moore, good afternoon. Your case is 25 CR 003261G. You're charged with simple battery. You understand your rights?
25, 2017 robbery conviction, 2012 grand theft, has a felony bench warrant and wanted out of Riverdale.
All right, thank you, Mr. Nixon.
Yes, Your Honor. This incident occurred on June 8th, 2025. Officer was dispatched to 2505 Old National Highway. Upon arrival at the location, officer was advised that the victim and defendant had moved over to 2471 Old National Parkway. And upon arrival at that location, the officer met with the victim, Roebuck, last name Latonia, Litonia, and the defendant. Ms. Roebuck stated that while she was at the bus stop on Godby Road, a female and male passenger boarded the bus. She informed them of the required fare, at which point the female passenger, identified as the defendant, stated that she could only afford her own fare and had no additional funds for her companion. Ms. Roebuck advised them that they needed to have the complete fare for both individuals before being seated on the bus. However, Ms. Moore ignored the instruction and proceeded to sit. Ms. Roebuck exited the bus and contacted the bus communicator. She stated that she and Ms. Moore exchanged words, after which Ms. Moore and her companion eventually got off the bus. Ms. Roebuck re-entered the bus and walked toward the driver's side, where the defendant threw a cup of milkshake at her body, leaving visible stains. Ms. Roebuck immediately called 911. Upon realizing the police had been contacted, the defendant fled the scene on foot, heading northbound on Old National Highway. Ms. Roebuck later encountered Ms. Moore, the defendant, at 2471 Old National Highway, where the responding officers also made contact with her. The officers reviewed the footage and confirmed the events with regard to this incident. I noted a warrant out of Riverdale for FTA 1, 2, 3, 4, 5 battery arrests out of California, as well as the 2024 theft by taking it, which was a felony here in Georgia. I think it was $4,000 surety as well. As such, the state is going to recommend a $2,000 surety for the simple battery. No further contact with the victim, no alcohol, drugs, or weapons while out on bond. And the state would also request that the court sign for the victim when appropriate.
I'm sorry, and I do need the victim's name again.
Sure. First name Roebuck, Roebuck. Last name, I'll spell it Litonia.
All right, is that party on the line and wishes to make a statement? Hearing none, Mr. McLean?
Thank you, Your Honor. Moore is 30 years old. She has worked at restaurants for the last 4 or 5 years. So she is very industrious. She has a high school education. We would ask the court, because of the nature of the case and without so much emphasis on the past, we would ask the court to consider a signature bond here. Thank you.
All right, defendant's gonna receive a $1,500 surety bond. Just have no contact with the alleged victim, stay away from that location, have no alcohol, no drugs, no weapons, and will be reset for the notice. Not for the notice, reset to all purpose on the 24th. Is there anything additional?
No, Your Honor. Thank you.
All right, best of luck to you. That concludes your case. Who do we have next?
Position 14, Newman.
All right, good afternoon. Your case, Ms. Newman, is 25 CR 003264B. You're charged with simple battery and battery. Do you understand your rights today? All right. I have first arrest, so Mr. Nixon.
Yes, Your Honor, this incident occurred on June 9th, 2025. The officer responded to 2730 Kayla Court in Atlanta in reference to a battery, family violence. Upon arrival, officers made contact with Jason Williams, the victim. Officers observed superficial injuries to the victim's face. The victim stated he and the mother of his unborn child, the defendant, were involved in a verbal dispute earlier that day. He reported that the argument escalated into a physical altercation when the defendant began punching and scratching him. Mr. Williams provided the officers with video footage showing the verbal dispute, as well as the defendant striking him in the face and head with a closed fist while screaming. Now, office has been in contact with the victim. The victim and the defendant are in a relationship. They live together at the incident location. Defendant is currently pregnant with the victim's child. Victim confirmed the events in the warrant and stated that this is the first time this has ever happened. Victim stated he is not in fear of the defendant and wants to continue contact and wants the defendant to return to the residence. As such, Your Honor, the state is going to recommend a signature bond through pretrial services, no further violent contact with the victim, Jason Williams, no alcohol, drugs, or weapons while out on bond, 1 day anger awareness, and the court, if the court gets down for the victim when appropriate. Nothing further.
All right, I'm sorry, his name was Jason Williams. Mr. Williams, I see you on Zoom. Would you like to make a brief statement? You're not required to do so. In the meantime, Mr. McLean, I'm going to give your client a signature bond with no further violent contact and the 1 day anger awareness unless you have an objection.
No objection. Thank you.
All right, defendant's going to receive a $3,000 SOB through pretrial services, $2,000 on count 1, $1,000 on count 2. She's to have no further violent contact with the alleged victim. I'm not going to require any type of stay away. She is going to take the 1 day anger awareness course and have no alcohol, no drugs, no weapons. Will be reset for the notice. I didn't hear from Mr. Williams, but Mr. Williams, if you're listening, I gave Ms. Newman a signature bond, and I'm not restricting her from contacting you. All right, who do we have next?
Position 15, Sims.
Ms. Sims, your case is 25 CR 003262J. You're charged with criminal trespass and damage. Do you understand your rights?
Yes, ma'am.
Thank you for saying that loudly. I appreciate it. Mr. Howard?
16, couple of probations from 2018, 2017 vice charge conviction, 2015 criminal damage to property, 2nd degree conviction.
Okay, thank you. Mr. Nixon?
Yes, Your Honor, the incident took place on June 8th, 2025. The defendant intentionally damaged the gas cap of Julianne Mayer's vehicle without her consent, and she aggressively pulled it off, damaging the vehicle. Our office was able to contact the victim. The victim stated that she worked security at the apartment complex and was telling some individuals that they were not allowed to have tents and grills on the property and that they needed to remove them. The victim stated the defendant then began cursing and yelling at her, sticking her head out the window and trying to pull her out of the car. Stated that she rolled up her window and the defendant began banging on her car and jumping on top of the car. The victim stated the defendant then picked up a brick and tried to throw it at her windshield. and stated the defendant broke the gas cap off of her car. The victim stated that there are also scratches on the hood, roof, and driver's side door, and stated that they do not have the defendant listed as a tenant in the apartment complex, and does not believe she lives there. I know there was a mention of a 2015 criminal damage to property as well. That was on first offender, but the first offender was revoked in 2018. With regard to the other criminal history listed by pretrial, the state is going to recommend a $500 surety for the criminal trespass damage to property, no further contact with Julianne Mayers, no alcohol, drugs, or weapons while out on bond. And if she's not a tenant there at the apartment complex, a stay away from the address, which I believe I listed. I'll get the address, but I think it's 705 University Avenue Southwest, but I'll take a look at that.
Okay, is Julian Mayers present, wishes to make a statement? Mr. McLean, I'm inclined to give your client a signature bond at level 2 with those requirements as requested by the state. Do you have any objection to that?
I do not, Your Honor. Thank you.
Question though, is she a resident of that apartment complex such that the stay away is active?
Well, I see the arrest 705 University, her specific address has the same address and gives an apartment number. So does the alleged victim have a different apartment number?
Do we have a unit number perhaps, Mr. Nixon, so we can exclude her from that location, but not the entire complex?
No, unfortunately, I just have the 705 University Avenue that's listed on the warrant here.
Okay, I'm not gonna exclude her from the entire complex. However, should you see the alleged victim, ma'am, you should turn around and walk in the other direction. Defendant is gonna receive a $3,000 signature bond through pretrial services at level 2. She's to have no contact with the alleged victim and stay away from the alleged victim's unit within that location. Have no alcohol, drugs, weapons, and case will be reset for the notice.
Next is position 20, Ms. Williams.
All right, good afternoon, Ms. Williams. Your case is 25 CR 0032554H. You're charged with battery, family violence, and simple battery, family violence in this case. Do you understand your rights?
This a second 2022 driving without a valid license dismissed.
Okay, thank you. Ms. Falk?
Yes, Your Honor. This happened June 9th of 2025. Sorry, is there some feedback? Apologies. This happened June 9th of 2025 at 1700 Sylvan Road in Atlanta. Officer spoke to Dedrick Hill, who shares a child with the defendant. Mr. Hill stated he and the defendant were in an argument. The defendant left and came back after receiving text messages from Mr. Hill. The defendant brought her 19-year-old daughter and a handgun. Mr. Hill took the firearm from the defendant, and then she began fighting him, causing visible scratches to his chest. The defendant was detained and the firearm was surrendered to APD. As you've heard, she has 2 cycles, and the other one was a driving while license suspended. We did have an opportunity to speak with Mr. Hill. He stated he and the defendant are not in a relationship. They do not live together. They do share a child. He stated that the incident location is his cousin's residence, and he did confirm the events in the warrant and stated this has never happened before. He stated he's not in fear of the defendant and is okay with no violent contact, and he wants the defendant to stay away from the residence. He also stated he did not wish to attend the Zoom, although we will sound for him out of an abundance of caution. The state's concern here is that she brought a handgun. She brought a handgun back to the scene and brandished it, and he actually had to remove it from her. This happened yesterday. So based on that, the state is asking for a $5,000 surety bond, $3,000 on the battery, $2,000 on the simple battery, no firearms. We're asking that she surrender any other firearms to APD or Fulton County Sheriff's Office, no further contact with Dedrick Hill, no alcohol, drugs, or weapons, and 2-day anger awareness. The reason for the no further contact is we believe there has not been a sufficient cooling off period, being that this just happened yesterday. We would like to, at this time, sound from Mr. Dedrick Hill. That's all for the state.
All right, Mr. Hill, if you're present, please turn on your camera, raise your right hand if you wish to make a statement. You are not required to. Mr. McLean?
We agree about the no contact for the cooling off period, but we would ask the court to consider a signature bond. We do understand the state's concern, but she will obey the court orders. She's got an 11th grade education. She's working on her GED. She's a homemaker and also has been a custodian in the past and also has been a school sports coach. She has 4 children, ages 18, 14, 11, and 2. And I think a signature bond would be sufficient to get her back into court on time. She has family here. She's from here. I've got her sis. I think a signature bond would be appropriate.
All right, defendant is going to I'm sorry, I lost my paper. Defendant's going to receive a $5,000 signature bond at level 2 through pretrial services, 3,000 on count 1, 2,000 on count 2. She's to have no contact with Mr. Hill. At this time, I do believe that there needs to be more of a cooling off. She's going to take a 1-day anger awareness course. She is going to surrender any and all firearms as delineated or as appropriate. She will be reset further notice, and I don't think I've missed anything. Have I missed anything from state or defense, anything additional?
You said
No
level 2?
further contact and
No.
stay away from his residence.
Yes, no further contact. I did say that because we said we're gonna need it to cool off. No further
Mhm.
contact and stay away. Anything else that I may have missed? Anything further from either state or defense? And it is level 2. I understand that, Mr. Howard.
Yes.
That wasn't the recommendation,
No,
but
I was just making sure.
yes, sir, level 2.
With no contact and stay away, there's it would be third party transfer of any visitation.
Yes, third party transfer if necessary.
Thank you.
All right, best of luck to you, Ms. Williams. Who do we have next?
Next is position 11, Kevin Harper.
Thank you. Mr. Harper, your case is 25 CR 003265F. You're charged with battery family violence, simple battery family violence, and simple battery. Do you understand your rights? I think that's a yes, Mr. Howard.
And got an open marijuana case. Sale of marijuana, possession of drug-related objects. 2022 reckless conduct, possession of a knife or firearm during the conviction. 2018 and 19 probation.
All right, thank you, Mr. Nixon.
Yes, Your Honor. This occurred on January 25th, 2025. Officer was dispatched to 2135 Godby Road. That's the Chelsea Apartments there in reference to a domestic. Now, upon arrival, officer made contact with the victim at the front entrance identified as Amaria Manning. And Miss Manning advised prior to the officer's arrival, she was assaulted by her live-in boyfriend, the defendant, inside their unit. Miss Manning expressed the incident occurred after she accidentally allowed the defendant's dog to escape the apartment. The defendant was complaining to Manning about the matter before Manning voiced that she went into the bathroom and talked to her friend via cell phone about the issue. The defendant then barged into the bathroom and questioned who Manning was talking to on the phone before grabbing her by the neck and punching her on the right side of her face. And there were visible red welts that were observed on the right cheek of Miss Manning's face. Now, our office was able to contact the victim, and the victim and defendant are no longer in a relationship. They no longer live together. They share no children. The victim confirmed the events in the warrant. They no longer live, again, at the incident location. And our office was able actually to do a further assessment. The victim stated that she was sitting on the toilet and the defendant was standing over her when he placed both of his hands around her neck and began to apply pressure. Victim stated that the defendant's grip was about an 8 out of 10. The victim stated that the defendant was strangling her for about 2 minutes and stated that she had difficulty breathing and felt like she was going to pass out. Victim stated that she had ringing in her ears and blurry vision, and stated that the defendant then pulled her to the tub with his hands still around her neck, and stated that the defendant then let her go and began punching her. The victim stated some more that the defendant broke into her new apartment in Clayton County on May 31st at that location, and the victim stated that she filed for a TPO after the incident, and she currently has an ex parte order granted on yesterday, June 9th. I have the TPO number. That is 2025 PO dash 02134009. Victim stated that the defendant left his 4 pit bulls in her apartment. Stated that she has not been back to her apartment since because she is afraid and wants no contact with the defendant and wants him to stay away from her residence. With regard to the criminal history, A very alarming 2023 reckless conduct firearm. There was 5 to serve 1 year. Defendant still on probation for that particular crime with the false imprisonment, where the defendant was firing a gun at another woman's feet. Therefore, due to the defendant's violent acts, the history of violence with the 2023 conviction, the victim statements with our office, our concern for the victim, the fact that he now has a history of violence against the woman or women in general, the state is requesting a $7,500 surety for the battery family violence, $3,000 surety for the simple battery family violence, and a $3,000 surety for the simple battery family violence. No further contact with the victim, Amari Manning. Stay away from 2135 Godby Road, as well as her new apartment complex. No alcohol, drugs, or weapons while out on bond. A 3-day anger awareness. We have recommended a transfer to the district attorney's office once we got the strangulation assessment back as well, Your Honor, and the TPO has been served on the defendant in the jail. The state would ask that the court sound for the victim when appropriate.
All right, thank you. Is Ms. Manning appropriate? Is Ms. Manning present, wishes to make a statement? All right, Mr. McLean.
Your Honor, Kevin Harper's 41 years old. Of those 41 years, he's been in Georgia 23 years. He went to high school here in Gwinnett County. Local contacts, local mail, good mail service. Also knows about going to the clerk's office if necessary to keep up with court dates. We discussed that you can't always rely upon the mail. Currently, he's living in Jonesboro, and let's see. His work history includes being a cook at one restaurant, being a cook at another restaurant, and doing the environmental and maintenance things at the airport. And we would ask the court to consider the lowest possible bond, signature bond if that is possible, and if that is not possible, we would ask for a $1,000 surety.
All right, thank you. Defendant is going to receive a $4,500 surety bond, $2,000 on count 1, $1,500 on count 2, and $1,000 on count 3. He's to have no contact with Ms. Manning and to stay away from the incident location as well as Ms. Manning's address. Additionally, he's to have no alcohol, drugs, weapons, and he is going to be reset to the all-purpose calendar on the 24th. Is there anything additional from the state or the defense?
No, Your Honor, thank you.
All right,
3-day
thank you.
awareness, possibly, Your Honor.
I'm sorry, say that again?
3-day anger awareness. Did you order that?
I gave him a surety bond, so I'm not going to do that.
Okay.
Part of it. All right, we're not going through pretrial. All right, everyone, please hold for 2 minutes for me. Thank you. Thank you all for your patience in that brief pause. Who do we have next?
Position 20, I'm sorry, Your Honor. Position 17, Mr. Underwood.
All right, Mr. Underwood, your case is 25 CR 003253B. In this case, you're charged with battery family violence, 2 counts, and simple battery family violence with the offense date of December the 6th of 2024. Do you understand your rights today?
No.
All right, thank you, Mr. Howard.
First resident of
Oh,
Alabama.
first, okay. All right, Ms. Falk.
Yes, Your Honor. This happened December 6th of 2024, so about close to 8 months ago at 3016 Piedmont Road. Janice Underwood, who is here today, stated she had been assaulted by the defendant, her husband, at the Waffle House at that location. She said they were in the car. The defendant took her phone, and when she tried to get her phone back, the defendant struck her in the face, resulting in a bruise around her eye and a scratch on her cheek. We did have an opportunity to speak with Miss Underwood. She stated they are living together now in Alabama. They share no children. They were visiting Georgia at the time of this incident. She did confirm the events in the warrant and said this had never happened before. And she does want to continue contact and is not in fear of the defendant. And there has been no violence since. We are requesting a signature bond through pretrial services. We are agreeable to phone reporting, no alcohol, drugs, or weapons, no further violent contact with Janice Underwood. She did state they are going to counseling, so we are not going to ask for anger awareness classes. That's all for the state. And we would like to sound from Ms. Underwood if she would like to speak.
Ms. Underwood, if you want to make a very brief statement, and again, the facts of the case are not in critical importance, it's just any concerns for your safety, please raise your right hand and unmute. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
That I would love for my husband to come home. I'm good with him being in the house, and that I don't want to prosecute or push this any further, if possible.
Okay. Thank you. I appreciate you coming to court and making that statement, Ms. Underwood. Mr. McLean, do you object to a signature bond through pretrial with phone reporting and no further violent contact?
We do not. Much appreciated.
All right, defendant's gonna receive a $3,000 signature bond at level 1 through pretrial services, 1,000 on each count. He's to have no further violent contact with the alleged victim in this case, and he is gonna report to pretrial services by phone. His case will be reset for the notice. Best of luck to you, Mr. Underwood. That concludes your case. All right, who do we have next?
Position 12.
Your Honor, just in case they have different terminology, when we tell him it concludes his case, he needs to watch that mail.
Oh, okay, right. I did learn that this morning at SAP. Your case is not concluded, but the hearing for today is closed.
Thank you.
All right, let's click that point of clarification. All right, who do we have next?
Position 12, Mr. Leon Love.
Mr. Love, your case is 25 CR 003260D. You're charged with furnishing alcohol to someone less than legal age and shoplifting. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
First.
Thank you. All right, Mr. Nixon.
Yes, Your Honor. This occurred on May 5th, 2025. The officer was dispatched to Fairburn Liquor Store at 42 Northwest Broad Street in Fairburn, Georgia. Reference to a shoplifting, the store manager explained to the officer that a group of 4 black males stole liquor from the store. The liquor stolen from the store consists of 3 bottles of Don Julio tequila and another bottle of tequila that totaled $466.52. The store manager advised the officer that the males came to the counters as if they were going to pay and asked for a bottle of tequila that was kept behind the counter. The manager stated that one of the individuals grabbed the bottle and all 4 of them ran outside into a Nissan. On May 7th, 2025, the officer made contact with the store manager. Officer examined the video footage of the suspects entering the store, approaching the counter, and leaving the store. In the footage, the officer observed the 4 males enter the store and leave the store with the bottles of liquor without paying. Officer was able to see all 4 of the males' faces on the video footage. The store manager also provided the officer with a clear photo of the vehicle's tag. The defendant was recognized as one of the males in the video on camera. The defendant was 19 at the time of this incident. With there being no criminal history, state's going to recommend an SOB through pretrial for the theft by shoplifting and furnishing, purchasing, and possession of alcoholic beverages by persons under the age, as well as to stay away from the Fairburn Liquor Store located at 42 Northwest Broad Street in Fairburn. No alcohol, drugs, or weapons while out on bond, and an anti-theft course.
Okay, Mr. McLean.
No objection.
All right, defendant is going to receive a $1,500 signature bond at level 1 through pretrial services per judge if necessary. 500 on count one, 1,000 on count two. They're to stay away from that location, have no alcohol, drugs, or weapons. Is there anything additional? All right, best of luck to you, Mr. Love. That concludes your case. What do we have next?
Position 19, Mr. Gay.
This is Mr. Whitehead, is that correct?
No, Dominique Gay. Position, I'm sorry, 9, Dominique Gay.
Oh, okay, I'm sorry. Mr. Gay, your case is 25 CR 003259Y. You're charged with criminal trespass and obstruction. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
22. On probation for entering auto. Trespass, another trespass and obstruction. On probation for another trespass and possession of drug-related objects. 2025 fade to appear.
All right, thank you. Mrs. Sirocco, please proceed.
Thank you, Judge. This incident took place June 9th, 2025 at 2000 Delaware Drive, Southwest in Atlanta. It's the Citgo gas station. At the location, law enforcement responded to a criminal trespass call and upon arrival met with the store owner, Mr. Kareem Kaba, K-A-B-A, who advised that the defendant was just on his property and had fled, and that the defendant, despite having received multiple criminal trespass warnings, still continued to return to his establishment, harassing customers. Officer was able to locate the defendant immediately, at which point he fled to the business beside the Citgo. The officer detained the defendant, spoke with him about the incident. He admitted that he was aware of being criminally trespassed at the location. And it was actually during questioning he managed to flee again. The officer was able to stop him and ultimately confirm again with the store owner that the defendant was the individual trespassing, as well as the previous criminal trespass warning for him. He was arrested on scene. The criminal trespasses in recent history, I did not have to go far to see that this is a pretty persistent problem on this particular stretch of road here, this Delaware Drive here. 2023 conviction, that was a Delaware Drive address. 2023, these are all criminal trespasses. Delaware Drive again, that's 3. And there's a 2024 also on Delaware Drive, a different gas station. And then you get to 2024, and then you have criminal trespass convictions for the same location as here. You have one from 2024, that is 24 CR 002108J, 24 CR 004063B, and 25 CR 000912Y. All those are criminal trespasses from the exact same location. There is clearly a risk of reoffense here. I see also a 24 PI 006905 criminal trespass that appears to be open there. In any case, he can't seem to stay away here. The state is asking for a $1,000 surety for the total, 500 surety for each count. Social worker visit for BHET. Stay away from 2000 Delaware Drive, Southwest Atlanta. No further contact with Kareem Kaba, and no drugs, weapons, or alcohol while out on bond.
All right, is Kareem Kaba present? Wishes to make a very brief statement? Hearing none, Ms. Tucker.
Yes, Your Honor. Mr. Gay is a 26-year-old Atlanta native. He did complete high school. However, he is currently homeless. He is also not employed, although he does seek side jobs by cleaning cars. He has no objections to staying away from the incident location, as well as no objections to staying away from the alleged victim in this case. We are requesting a signature bond despite the recent failure to appear that's on his record, due to him having no income and his inability to afford to pay for a bond at this time. We have no objections to the state's further recommendations on this case.
All right, defendant is going to receive a $10 cash bond, $5 on each count. He's to stay away from that location, have no alcohol, drugs, weapons, and I am going to request a social worker visit. Is there anything additional from the state of the defense?
Is the judge inclined to grant the no further contact with Mr.
Oh,
Kareem?
that's true. That's true, even though it's a criminal trespass. I don't typically like to do that. All right, and no further contact with the alleged victim in this case, Mr. Kabah. Best of luck to you, Mr. Gay. That concludes your case at this time.
Next is add-on 1, Mr. Vincent Williams.
I know I had it. Give me 1 second. It's here. Give me 1 second. All right, Mr. Williams, your case is 25 CR 003255B. In this case, you're charged with DUI, DUI less safe, DUI under the influence of alcohol, under the influence of drugs, driving while your license is suspended, defective headlights, obscured or missing license plate. Do you understand your rights today?
Yes.
All right, I want to confirm there are 6 counts on this, Ms. Falk.
That is correct, Your Honor.
All right, please proceed.
So
This
this
is
ha-
eighth.
Oh, I'm
Oh,
sorry,
This
Mr. Howard.
Mr. Howard, my
I'm
apologies.
so
This is
sorry, Mr. Howard. Go ahead.
eighth arrest. Got an open DUI to Johns Creek. 2024 suspended license NOLO. 2019 DUI conviction. 2011 theft by receiving first offender. He is wanted out of Gwinnett County.
Okay, thank you, Mr. Howard. That's informative. Ms. Falk?
This happened June 9th, 2025 at 12:15 a.m. on State Bridge Road in Johns Creek. Officers observed a Nissan Altima without a passenger side headlight. They performed a stop on the vehicle when they saw that the tag was obscured as well. After blue lighting the vehicle, the defendant continued traveling at a slow rate of speed for about 1.2 miles, driving past a well-lit parking lot and finally coming to a stop at State Bridge Road and St. Georgian Common. Officers smelled the strong odor of marijuana and alcohol coming from the defendant, the driver, which is what led to us doing charges in the alternative. The defendant was read implied consent for blood and refused to give an answer, and the defendant's license showed suspended in the system. As you've already heard, the defendant has a prior conviction for DUI from July 22nd of 2019, a pending case in Johns Creek for DUI in April 20th of 2024. He also has a NOLO for driving while license suspended from July 17th of 2024. And just to add in on this, the defendant had a 2016 DUI arrest that was null prossed in 2018. So in the span of 10 years, this is the 4th time he's been arrested for DUI. We are asking for a $5,000 surety bond. The surety bond was already preset at $4,000. We are requesting $1,000 on each DUI and driving while license suspended, and then $500 on the headlights and the obscured or missing license plate. We are also asking that the defendant not operate a motor vehicle since his license is suspended unless his license is reinstated. That's all for the state.
Mr. McLean?
Your Honor, 34-year-old Mr. Williams works in a restaurant. He's done so for 8 years. He's a high school graduate and also is halfway through his 4-year degree in business administration. He's going to finish that up at Payne College in Augusta. Because the 3 DUIs here are in the alternative, of course, ultimately a person would be responsible if these are true. For one, we would ask the court to take that into account in fashioning the mathematics. Your Honor, the Snellville hold is simply for an old car that in the driveway or something, and he's already sold that car as instructed by the environmental citation people. So that is not going to be a problem. we would ask the court to set the bond as low as possible. Thank you.
All right, defendant's gonna receive a $3,000 surety bond, 500 on each count. He's not to drive unless he has a valid license. And he's have no alcohol, drugs, weapons as a condition. He is going to be reset for the notice. No, I'm sorry, he's going to all purpose because he got a surety. I'm sorry, I was looking at something else. All right, so he's going to all purpose on the 24th. Is there anything additional?
Nothing from the
Nothing.
state.
All right, best of luck to you, sir. That concludes your case.
That a bond is 3,000. You have to pay 10%. Your Honor, we have Mr. Jaden Ficklin. We're not sure, he was not on the regular calendar and we did not receive an add-on for him.
Your Honor, I can address that.
Okay, please do, Ms. Falk.
Mr. Ficklin was alleged to have shot at a victim. So we have asked the DA's office to examine that case as a felony aggravated assault. We are waiting for their response. We did not accuse the case, and we are asking for a one-day reset. We are still within the period of time where Riverside would not be an issue.
All right. What happened to position 19? Did we do 19?
Can you give me the name of the case, Your Honor?
With Whitehead.
Yes,
Yes.
Oh, we did?
My
notes, clearly I don't know what my
If you want to
notes,
take it away.
clearly I don't know what my notes were for that one. I had 2 copies of the calendar and it was very confusing to me today. We do position 1, 2, and 3?
No,
Is there an announcement for those?
no.
Hi, everybody.
Hello.
Position 1, 2,
3.
3, behavioral reset.
Oh, okay.
Yeah, Judge, he refused to come to court yesterday as well.
Right.
Same thing happened.
Here we go with that. Okay.
Your Honor, can this time we just ask that a courtroom 2, if a cell phone can be brought to court tomorrow, just in case we have to bring it to a cell?
We can try. Do you all have the ability? I've tried that a couple times, Ms. Falk, and no one's been able to do that recently.
Okay.
But I'm gonna request, is it possible to do that for tomorrow?
We'll try our best.
I understand. I know that you will.
Thank you, courtroom 2.
You're welcome.
All right, I believe we've completed the entire calendar, and clearly I'm gonna be relying on Ms. Bridgewater, as it's been a very long day today, and I don't really remember where I am or what's happening. So Ms. Bridgewater, please take it away and review our calendar for us.
Yes,
Thank
I will.
you.
Ms. Bridgewater start. What did you say about position 19?
We have an order for it, and I'll give you those the details in just a second, okay?
No problem.
Okay. All right. Once again, the reset date for the SAP calendar is June the 24th. Positions 1, 2, and 3, we're going to try it again tomorrow. So therefore, it'll be reset to the SEA calendar for tomorrow. Position number 4 is going to the SAP calendar with a $5 cash bond. Position 5 is also going to the SAP calendar with a total $2,500 good bond. Position 6, SAP calendar with a total $2,000 good bond. Position 7 is reset further notice with a $4,000 SOB through pretrial. Position 8 is reset further notice with a $5,000 SOB through the jail. Position 9, SAP calendar with a total $10 cash bond. Position 10, SAP calendar with a total $1,000 good bond. 11, SAP calendar with a total $4,500 good bond. 12 is reset further notice with a total $1,500 SOB through pretrial per judge. Position 13 is going to the SAP calendar with a $1,500 good bond. Position 14 is reset further notice with a total $3,000 SOB through pretrial. 15, reset further notice with a $3,000 SOB through pretrial. 16, reset further notice with a $2,000 SOB through pretrial. 17, reset further notice with a total $3,000 SOB through pretrial. Position 18 is going to the SAP calendar with a total $8,000 good bond. Position 19 is being reset further notice with a total $1,000 SOB through the jail. 20 is reset further notice with a total $5,000 SOB through pretrial. And for the add-on calendar, it is going to the SAP calendar with a total $3,000 good bond. Are there any questions, comments, or otherwise?
Hearing no changes, comments, or questions, we will be in recess until court tomorrow, at which time Judge Law, I believe, is presiding. Take care, everyone. Have a great afternoon. It's wonderful seeing you all. I will not be with you all for quite some time, so enjoy. Bye-bye.
Bye, Your Honor.
Bye,
Take
Judge. Thank
care.
you.
Oh, you slid that one in. Okay.
I'll be gone for a while, Miss Bridgewater. Take care.
Okay.
Okay, bye-bye.
Bye-bye.